Howdy, and welcome to the White Hat Law Show with Warren Nord, where we cover a mix of current events, politics, and the law. Take it away, Warren.
Welcome back to White Hat Law. My name is Warren Nord. I'm an attorney here in Arlington, Texas, in Tarrant County, and today I'm joined with Dr. Jim Gray, who practices dentistry in downtown Arlington. Actually, not downtown. Where exactly are you?
I'm at Center and Mitchell Street, right by the university.
And how long have you been there?
I moved to Arlington in 1993, so 24 years.
So you're not really accepted yet as an insider.
I'm not an insider.
Okay. Well, tell me, what do you do? Are you a general practice in dentistry?
Yes, general practice. We do all phases of dentistry and sleep medicine.
Sleep medicine. Well, fortunately, we're not here on that today, but we are here on trademarks. You called me about a trademark issue a few years ago. Let's talk about that.
So I had a website built in about 1997, and our practice is committed to taking good care of patients and having long-term relationships, and we came up with a web address of Smiles for Life.
Smilesforlife.com.
Smilesforlife.com. And I got a phone call from a dentist in Texas who was interested in naming his business that, and asked me if I had trademarked it. And I became a little bit concerned because I had not, and I found that I could actually lose my URL. And so I called you, and we started the process of trademarking my business.
Yeah, it brings up an interesting issue, and this happens a lot. People have a registered for address on a domain, URL, and they believe that they've got it protected. Some people think they've got it protected as a trademark whenever it's just an LLC name. Of course, neither of those are true, as you found out.
Right.
So we filed the registration for your mark, Smiles for Life, in 2013, 14, end of 2013. And 5 months later, we got what? Office action? It's an office action. An office action is a letter from the trademark office that says we're rejecting your application for one reason or another. And usually it's for likelihood of confusion with somebody else who already has a mark. In that case, in your case, it was Smile for Life with the number 4.
Number 4, right.
And so as we discussed, we had several options, right? We could ask him for permission. We could sue him and try to get it canceled for some way because you'd had it a lot longer than he had. Yeah. There's lots of things we could do. And the reason we're talking about this story is because it has a happy ending in that we contacted him, and of course, your practice is mostly DFW people, right?
Only DFW people. Right.
And most dentists don't have a geographic footprint that's larger than the nearby city and area.
Right.
So if somebody has a federal trademark and is a dentist, they really don't need it over the entire country. They really just need it in that area. So we contacted that individual, and he said, sure, I don't have any problem with this, and he granted permission. So we had something's called a concurrent use statement, an agreement. Right. We sent that in, and that was taken in by the USPTO, the United States Patent Trademark Office. In this case, we shortened that to just the Trademark Office, and they said no problem. And they gave you your certificate.
And we thought we were done.
And we thought we were done. And then, the Trademark Office came back and said, we want to redo this. You haven't filed the suit. In the trademark world, you can file a lawsuit to cancel or somebody else's mark, or to have a concurrent use registration. And there's a lot of technicalities to it, but the basic idea is that sometimes you have to have a suit, and sometimes you don't. The Trademark Office, even though we had the registration in hand, asked us to go back and file the suit, which, of course, the other dentist said, I thought we figured this out. This is a done issue. So he didn't fight it, and now today it's all complete, and you have your registration.
But as we were talking, I am only registered in Tarrant County in the 5 or 7 contiguous counties.
Right. It's just a geographic area around here.
Right.
And as it turns out, we could probably go back and get it all now because the other one has gone away. So that's something we can do in the future.
Yeah, I was looking over the paperwork. I didn't realize that you have to renew that every 9 to 10 years.
It's between the 5th and 6th year, and then every 10 years thereafter.
Oh, okay.
So every 10 years after the first one. So the first time is between the 5th and 6th year, and the second time is after the 10th year.
Okay.
And then it's every 10 years after that. So 5, 10, 20, go on. And you can keep it as long as you want, as long as you're actually using it. You have to file a statement of use. I'm glad you brought that up. If you don't file your statement of use, then you lose your trademark. It goes away.
Okay.
And every month, you can look up and see trademarks that go away. And there are people who either had an attorney who's retired and it's not high on their priority list to let them know, hey, we need to have this redone. Or it's a situation where they don't care anymore. Or they just don't have the wherewithal to take care of it. And so these trademarks, they don't have a shelf life as long as you maintain them, but you do have to maintain them.
So ours was like a 3.5-year process to get it done. When does my 5-year first renewal start?
It starts 5 years after it issues.
The final issue,
That's correct.
The real, okay.
When we go on,
The one they're recognizing.
Yes, and it's funny because the Trademark Office goes through phases. There's no law that says they have to let you know, hey, your 5 years is coming up. But sometimes they do because they know that that's a beneficial thing to do, and the USPTO is one of the few areas of the federal government that makes money. It's a profit center for the federal government.
Okay.
So they know that if they let people know, they'll send in their applications, and it's a simple task, so it's a money-making operation for the USPTO, and it helps everybody. But then they'll go through phases when they don't have to do it, or they don't want to do it, so they don't do it, and the world has to adjust. So today, I'll wind up getting a letter because I'm your contact for your trademark, and it'll say, hey, what about this? I'll get that right after the 5.5 years are up, or after the 6 years is up, and you'll have to pay a late fee if that happens. If I'm doing my job right, though, and setting myself up for the malpractice suit, that shouldn't be an issue. We should be okay with that. And then after that, it'll be the be another 5 years later will be the 10-year anniversary, and after that, it's every 10 years.
Okay.
So your son or daughter or whoever takes it over, you'll assign it over, and it'll all be great, last forever, which is pretty common. That happens a lot. So that is what we have to do for, and I like the story because it shows that a trademark can be simple, and you can even think it's done, and it's not. You can look it up. When we look up Smiles for Life, we don't pick up the other registration because it's a number 4.
Right.
Now, sometimes people will get very creative, and they might use a $ instead of the S. So you have to really look at a lot of permutations, and you can look at a lot of them and still not catch one that's going to be a problem.
Right.
But in this case, we found a reasonable person on the other side, and we got it done. But you can see the timeline. We filed it. We got our first office action 5 months later. Sometimes people call and they'll say, I want to have this trademarked, which is code. It's a simple way of saying, I want to register the trademark. You had the trademark for a decade before you filed it. You still had the trademark, it just wasn't registered.
Right.
So these things kind of come into play, and it's always easier if you file the trademark earlier than if later, because obviously if this other fellow had not been so amenable, it might have been a real problem. We still would have won because you'd been using it a lot longer than he had, but it's money, right? Nobody wants to do that. So the moral of the story.
He was in another state.
Right. He
was an orthodontist.
Right.
Which
is completely different from dentistry. To some people, to most people, actually, I guess. But anyway, so if you have a trademark issue, or if you've been in business for a while and you're using a trademark and you want to make sure that you're not going to run into these problems later, or you want to stay away from getting cease and desist letters, then give us a call, and we'll try to make sure that you are protected from involvement in trademark disputes by getting ahead of the game. Thank you. We'll be back in just a minute.
Hang on, y'all. More with Warren when we get back. Welcome back, folks. You're listening to the White Hat Law Show with Warren Norrid. Take it away, Warren.
Welcome back. I've been joined today with Brian Blue of Blue Knight Agency, who is our partner in this podcast effort.
That's right, proud partner.
Yeah, and so we've been talking about trademarks, and of course, Blue Knight Agency works a little bit in trademark world.
Yes, we do a little bit. You know, we service all types of clients, all different sizes, and the common thing that I always run into is what exactly is a trademark, and how does someone go about getting one?
What an opportune question. A trademark is a brand name, a symbol, a device, anything that identifies the source of a product or service. Doesn't have to be registered, doesn't have to be a word. The classic Coke bottle is a trademark of Coke. If you had all of the different kinds of soda pops, or whatever we're calling these days, Cokes and Dr. Peppers, and you turned off the light, an average American citizen could pick up the Coke bottle and say, this is a Coke by its shape. So anything that identifies the source of a product. So people don't think about these things as trademarks.
Yeah.
But going down the highway, you need a quick lunch at a clean restaurant, you see the golden arches.
Oh, yeah.
You know, anything like that. Buying tennis shoes, you see a swoosh. You know who made that product, and you know that you can use that. So some marks are registered and some are not. NORAD law I used for many years without a registration. It's perfectly okay. You can't get a trademark until you've used it commercially.
Okay, yeah.
Probably number one question that I get.
So then, let me ask you, what is your business name synonymous with a trademark?
Sometimes not.
Okay.
Who owns Subway, the Subway franchise? A company called Doctors Associates.
Oh, okay. I never knew that.
Some people know that, some people don't, right?
Yeah, no.
But who'd have thunk, right?
Yeah, right.
So it's
No doubt.
Doctors Associates owns Subway.
Yeah, right.
So it's pretty common for people to have a business name, and then they have an assumed name, which should be registered so people see it.
Okay.
And then they use that name to go to market.
But you can't just have a business name or even a domain and be safeguarded to think that's trademark.
Yeah, it's a common problem. People will come into my office and they'll say, well, I've got my noradlaw.com, the equivalent thereof, and therefore I've got a trademark, right?
Oh, yeah.
Well, if you're using that in practice, in commercial services, you do have a trademark, but it's not registered. These are all government agencies, but they don't talk to each other. So you can have a URL domain, and you can have an LLC that's named something, and you could be infringing somebody else's mark. They don't all talk to each other. So a registered trademark has to be registered by itself as a trademark. The fun part is you can register it on the state level or the federal level.
Okay, that's good news.
It's cheaper on the state level, but it's less effective. So maybe 10%, not even 10% of our clients say go ahead and register it with the state.
Would you mind me asking, what does less effective mean?
Less effective means if somebody in Oklahoma decides to use NORAD law, and I only had it registered in Texas, then I couldn't stop them in Oklahoma.
Oh, okay. I didn't know that.
I could sue them under the common law, maybe. I have to figure out what the laws in Texas and Oklahoma are.
Right.
But I couldn't sue them under a registration. So I have to have the federal registration to stop people nationwide.
Yeah,
In the previous segment, we saw a dentist doesn't care about stopping people in Maine.
Yeah, of course not. Yeah.
So they often you're overkilling when you get a federal registration, but you just recognize that because it's like getting too much armor.
Yeah.
You can't have too much armor.
Yeah.
So it's perfectly okay to overreach.
Yeah, well, I can definitely know armor I can get, I can tell you that. Let me ask you, you mentioned common law. So is Texas a good default common law state? I mean, I guess what I'm trying to ask is, are you protected if you go down and you registered billsbarbecueshop.com and you don't do anything with it for 10 years and then someone else in Texas opens it up, or is it pretty lax? Is it strict liberal? What would you say?
Well, most of these things come from the common law.
Yeah.
Okay. Intellectual property generally comprises copyrights, trademarks, and patents.
Okay.
And copyrights and trademarks go all the way back to the Queen's Bench in England. So if you were John Smith and you had a smithy in South London,
Yeah.
and the guy in East London decided his name is Jack, but he's going to go by John because he's going to glom off your goodwill.
Right.
Well, you could tell the constables and make him change his name because he's even though there's no law, that's what we call the common law. So it comes all the way back from that era. These days, most intellectual property issues have been codified with statutes.
Yeah.
But the statutes do take into account if you've been using your name for 30 years, you never registered it anywhere, and somebody comes up tomorrow and then registers it and starts a new business and then tries to stop you, you're going to win.
Yeah.
Now you're going to receive a lawsuit and you'll have to fight that, but you'll win as long as you have a few bullets in your gun.
Okay, so what about then, and a lot of my clients will say, we come up with a great slogan, a great motto of some sort, or a campaign, and we go to trademark it. How do we keep an eye on it? You know, I mean, is that something you provide to your service?
Attorneys, intellectual property attorneys often offer that service.
Yeah.
And sometimes people like it or don't like it.
Yeah.
It's there is a statute of limitations on trademark infringement. You do want to watch for those kinds of things, but usually it comes up pretty clear, pretty fast if somebody's really infringing, and you in a way that you care. The hard part is knowing when to register.
Yeah.
People will come and say, "Well, I want to register this." Trademarks are built, and they're not a trademark until they're used in commerce.
Right.
That's the whole point.
Right.
And so now let's say that you're going to have a set of commercials centered around the most interesting man in the world.
Okay. Well, I didn't know they were going to do one about me.
Yeah, well, there you go. Well, we like to play into the sensibilities of the people we work with, right?
You got it.
So they want to make sure that that's not already taken.
Sure.
You can do what's called an intent to use application.
Okay.
And the trademark office looks at it and says, no, there's nothing in the way. You can start spending your money on all these commercials, and we'll hold it in place until you actually use them. Then you file a statement of use. So it's a little more expensive to do it that way, but that way you keep from wasting a lot of money on something that's not, you may not have availability to. But it's when people say, well, when do I do this? I tell people, look, if you've got a small amount of money and you're a new entrepreneur, first you get your LLC, get that working.
Yep.
Pick a name that's not probably going to be used and talk to me or one of my friends and say, is this likely to be not taken, in 6 months? And then we check that out, make sure that's not going to be taken for the LLC, so you don't have a problem with your LLC or your business or corporation, whatever you're starting. And then once you get going, then you go ahead and file your trademark. Now, if you want to be sure and you've got a few more dollars in the pail to put toward the effort, then we do the intent to use first. Or if we want to use something that may be taken.
Yeah.
People sometimes come and they want to say, well, I want to have a mark that I don't know if I can get that for you or not. Discount tires is one of my favorites.
Oh, yeah, sure.
What does that describe? Discount
Cheap tires.
Right? And
Right.
So it's pretty descriptive.
Well, let me ask you and interject.
Sure.
So those are two common phrases, though, or two common words. Can you actually trademark something that common?
If you're discount tires, you can. But
Okay.
you have to spend a ginormous amount of money.
You really got to.
And if you look them up today, they had to disclaim the word tires because it's descriptive. You cannot claim the word tires
Right. Yeah, of course.
to describe in your trademark the sale of tires. You can't grab that.
Right.
Of course, they're all discount tires. Well, that's pretty descriptive too.
It is.
Verging on generic, but Discount Tires did a huge study and survey and showed that when people say, I'm going to go to Discount Tires, everybody knows you're going to a place called Discount Tires.
Yeah.
So we've worked through these things, but typically it's better to say, why don't you rename it Joe's Discount Tires?
Why compete with Discount Tires? They probably got a bigger budget than most of them.
Yeah, they could do that, but they didn't do that until after they were huge.
Yeah.
They didn't do it when they were young. So,
well, let me ask you: do you have some sort of a case study? Maybe you can help me wrap my mind around, or something that's come up.
it's an excellent question. It turns out I do have one that kind of where we helped a client through a lawsuit concerning infringement.
Okay.
And we'll address that when we come right back.
Whoa, hang on to your hat, folks. More with Warren Nord when we get back. Y'all are back here listening to the White Hat Law Show. Warren, who do we have up next?
Welcome back. I again have Brian Blue of Blue Knight Agency with me, and a few minutes ago, Brian asked me about enforcement actions and trademarks and cases that might be interesting, and I happen to have one handy that we call it's a trademark bully case.
All right, let's hear it.
There are people who have trademarks that they have received registrations for, and they go around intimidating other people who are, I use the word unsophisticated, but what I mean by that is people who don't know the law.
Yeah.
And they get these nasty letters, and I have one of these in front of me that a friend of mine actually received.
Oh, wow.
And this is the actual letter, and we won't post this one, but we'll post some of the other things about this in a minute. This law firm has been retained to prosecute the violations of the intellectual property rights into back-to-back World War champs branded products. And what this company had done is they had registered the mark for back-to-back World War champs. Now, as you may or may not know, this is a very popular shirt that the kids wear. Both my boys have one of these shirts.
Yeah.
They bought from a rowdy gentleman in Austin.
All right.
And it's kind of these hipster shirts. You know, they sell a lot of Reagan shirts and things like that too. But it's just the front of the shirt, and it says United States back-to-back World War champs.
Okay,
right? It's kind of cute, right?
Yeah.
And so he got this, and he sells shirts online in his online store. And I got a hold of this, and I started looking around at it. And they had gotten this registration. Of course, you're not supposed to be able to register political slogans.
Okay.
Political slogans are not part of that.
Yeah.
But you had some examiner at the trademark office that didn't know any better.
Of course.
And so they got it through. And if you look at the trademark for a T-shirt, you know, it's back here. If you look at Through the Loom T-shirt, you know, it's back here on a tag, right?
Yeah.
That's where the trademarks are. You don't see a back-to-back World War champs as a political slogan on the front of a shirt and think, oh, that's where that's from. You know, it's not being used as a trademark.
Yeah.
It's not indicating the source. So it was a bad threat. And I did some research on this. These guys have done this many times and found out that what they're doing is they're shaking down small T-shirt manufacturers. And so my friend came to me and said, what are we going to do about this? And this is kind of if you get a cease and desist letter, demand letter from an actual attorney who says, I'm going to sue you unless you do this, then you have to go talk to an attorney.
Yeah.
You got to know what you're doing, right? It means business. It doesn't necessarily mean you're going to be sued. It doesn't necessarily mean that you're guilty or innocent, but you got to talk to somebody.
You figure out what the threat is.
Right, figure out the threat. So we looked at this, he asked me to talk to this fellow, so I sent him an email, and I said, hey, I see this. This is kind of a novel theory that you can use to say that this ornamental use of a political slogan can be an infringement of your trademark.
That sounds confusing already.
Yeah, it's messed up. And I said, it's cute. Can you show me any case law that supports this?
Right.
And,
yeah, of course.
And he wrote back with this real snarky, well, thank you, Mr. Norrid, for admitting that your client is infringing. Oh, you know,
here we go.
Pound sand, buddy. And so we took this on as a white hat law case, which, as we discussed, of course, is the white hat law show.
You're the good guys.
We're the good guys, and this guy was a total jerk.
I bet.
And he deserved our attention.
Oh, yeah.
So
how'd you pull out the guns?
We filed a lawsuit in federal court here in town.
Wow.
He's in California. Because the danger here is if you don't do what he wants you to do, then he can sue you, right?
Can I ask you a quick question?
Sure.
How do you select venue when someone out of state sues you? Do they have to do venue here in Texas?
They're supposed to.
Okay.
But they will. It's a problem. It's a litigating point.
Yeah.
You'll file it in your home city, and make them come to you.
Got it. Okay.
And so they sent us the demand letter. It was a real threat, and so we filed our suit here.
Got it.
It's always safer to file it where they are.
Right.
But it's a lot more expensive.
Of course,
right?
yeah, that's what I was thinking.
Local counsel, and it's a real pain.
Yeah.
And that's why they usually file their cases in California.
Of course.
Because you have to come there, and it's hard.
Of course.
Even winning is hard, right?
Oh yeah.
And so we filed here, and it was a claim of non-infringement, a declaratory judgment seeking non-infringement.
Yeah.
But we went further than that. We wanted to cancel their trademark because it should not have ever been issued. And we wanted to go after them for anti-monopolization.
Oh, wow.
Under the Sherman Act.
Yeah, go for it. Yeah, why not?
I mean, we're going to pound these guys.
That's it. Yeah, no doubt.
Now, under normal rules, if you have a legitimate trademark dispute between two oil companies or something like that, you can't make a Sherman claim. That's for a claim. This is totally wrong. You are totally wrong. You have no justification for what you're doing.
Yeah.
So we were really going after them pretty hard. As you may or may not know, in federal court, the first several months is almost always a motion to dismiss.
Mm-hmm.
So we had to go through that a couple of times. And after a year's worth of motions to dismiss, the court said, no, we're not going to dismiss this. This is a real case.
Got it. Wow.
They came along. They said, look, okay, we'll let you do what you're wanting as long as you're not on eBay or Amazon.
Got it.
So I got this email. We'll settle with you, eBay or Amazon. No, and we said we want to pretend you don't exist. We're not going to sign anything that
Fighting back
restricts
strong.
us
I like it.
in any way.
Yeah, you're not cutting any slack.
Now we will,
It's good,
in return, we will not go after your trademark because it really kind of helps us.
Of course, yeah.
Because it keeps out these people who are not willing to fight back.
Yeah, of course, yeah.
And that's what we wound up doing. So nearly 2 years after we started, they agreed to a settlement. And I can talk about it now because my client has given me
It's
the
all
okay to
public
talk
information.
that. And the settlement was effectively open, and there was no confidentiality on that. So, and I'll say that not every case goes like this, right? But this one did, and we agreed to go forward and drop the suit if they would leave us alone and not bother us again.
Wow.
Now the fun part is during this, people talk, right? So I had a number of I had about 24 other potential clients that came and said, we want this too.
Save us.
So I got a couple of other people that joined in the fray.
Good for you.
And we had a number of things that would happen that was interesting. But the fun part was telling these guys, no, you don't get to go around bullying people like this. You got to go elsewhere if you're going to play these games. We're not going to put up with that here.
Yeah.
And so they will leave people alone.
Boy, that's good to hear. I definitely understand that. I'm not quite in trademark, but I've been through those cases where it's good when the good guys win. You know.
Right. Well, it's as a white hat law case, we said no. This is fun.
Yeah.
You know, you're on the right side. Of course, we didn't charge but a fraction of what we spent on it, but we thought it was a good public service. It's not something anybody can do, you know. So
well, here's the thing: if everybody's listening, if you have any federal trademark suits, go to Warren.
That's
You're going to be in good graces with the courts right now. I know. So
well, we do fight for the good guys. The fun part that I found out about this later on was that there are many, what I'll say, unnamed big box retailers that paid these guys tens of thousands of dollars to get out from underneath it.
oh my word!
And
But to them, that's a small issue. That's a settlement issue.
yeah, it's just a business decision.
Yeah,
and just kind of fed what you're doing is you're feeding the bear and you're encouraging them to do more. So I always say, look, you know, fight back if you have the wherewithal to do that, and if you can, just fight back. I mean, our client today does not sell T-shirts. He went away from doing that, but he was one of those guys that says, look, you're not pushing me around, and I've got a warrior here on my side. We're not doing that. So it was a lot of fun. So the moral of the story is, do something with your cease and desist letters.
Oh yeah.
And don't think you have to roll over just because somebody says roll over.
See, that'd be my question for you. If a cease and desist letter came and it said stop using immediately, of course I'd go find an attorney. But should you stop using it immediately?
No.
What should you do outside of finding an attorney? I get it, but you know.
If it's going to be a month before you find an attorney, then you might be circumspect about what you're doing. In this case, our client took down those shirts off of his website. It was easy to do. But sometimes it's not easy to do. Sometimes it's your entire business. We had a case in Weatherford where the guy wanted an injunction to make the guy stop using his name that's on the sign of his store. So that's a substantial change, and so we had to react fast to that and fight back. And so these are people who just, quite often, they're well connected, they've got a lot of money, and they see somebody who's challenging them in a marketplace, and they're just going to cause havoc and pain until they change their ways. And what they need to do is they need to get it right back and help them understand, no, this is not going to go easy for you, it's not going to go well for you, and you're going to look like an idiot in court.
Wow, yeah, that's good to hear. Well, I know how I'm going to use. Free trademark, there it goes.
Well, there you go. On that note, we appreciate your attendance, and we hope to see you soon.
Well, that's a wrap, folks, and we want to thank you for listening to the White Hat Law Show here with Warren Norrid. To find out more about Warren, check him out at norridlaw.com. See you next time.